It's a nice kind of practice to have everyone have to deal with and I think even cut back on that, I think I've got 10 assigned cases and 10 AFCs. Everybody knows. Yeah. Your appeals?
The Justices of the Appellate Division Fourth Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case number 6, People versus Richard White.
May it please the court, I'm Ed Dunn on behalf of the Hiscock Legal Aid Society representing Richard White. And the guilty verdict of robbery second was not supported by sufficient evidence because there was no testimony that Mr. White was aided by another person actually present, which is required by Penal Law Section 160.10, paragraphs 1. This is a necessary element of that crime. There is testimony throughout the transcript regarding Stephen Herzog, who is the alleged accomplice, but nowhere in any of the mention of him in the transcripts of the trial or otherwise is there anything that says that he acted.
Counsel, let me ask you this question. It says aided by another person or actually present. The fact that the co-defendant says he was within 50 feet and the victim was aware of the co-defendant's presence.
Yes, Your
And
Honor.
there appears to be some cases that kind of reference the fact that he's there and he's visible could have an intimidation type of factor, or just because of his presence that the victim may see now, instead of one robber, there's 2 people. Is that enough?
That's correct, Your Honor. But there is, he says, that as Herzog says nothing to the effect that he is working.
No, but he's visible.
Yes, Your Honor, but and it could be inferred from that, yes, but it's not proof beyond a reasonable doubt.
Okay.
Thank you.
Thank you, counsel.
Judge, if you like to speak briefly about ineffective assistance of counsel, which was
Absolutely,
which
counsel.
was
You
my
get time.
second point. Thank you. The trial counsel introduced excluded testimony that Mr. White, the appellant, had been convicted of criminal impersonation. And, Judge, that hurt the appellant's case considerably because his defense was an alibi defense, and that he was not there at the time that the crime was committed. There is no logical reason, there's no benefit that could be reaped from introducing that testimony. And
well, might he not want to introduce it before the people did on cross?
I think it was introduced before that, Your Honor. I'm sorry.
I think Judge Troutman means to blunt it so that the jury's not hearing it for the first time.
Oh, I'm sorry. Yes, that could have been a possible.
Right, but what was the court Sandoval ruling on that? Did the court That would make sense to blunt it if the court allowed questions about criminal impersonation. What was the standard vote?
The trial court told counsel that they were not going to allow that conviction in.
So you're telling me the court ruled that precluded it? I looked and I didn't really see where the court actually, the transcript doesn't say that the court excluded the criminal impersonation.
What the record says, Your Honor, is that there are certain crimes that the court would allow.
Okay.
But it was, I think by omission, it was clear that.
Okay. Fair enough.
Can I ask you a question about
Sure.
the sentence? Your client, what exactly is his prior criminal record? He had a robbery third from 2015.
That he was on probation for.
Did he get straight probation for that, or was it shock probation?
I'm not sure.
Do you know what the circumstances of that robbery were? Is that
No.
set forth in the PSI?
No, it was not.
So he's got a robbery and he's got some misdemeanors.
Yes.
He was offered 7 concurrent for 2 robberies. He was acquitted of 1, and he gets 14. In your view, that's
Yes.
harsh and excessive.
He was only 21 years old at the time that this incident occurred. And he was a special ed student who only made it to 8th grade.
Yeah, we understand. He did get up there, and his mother apparently committed perjury, though, I understand that. Is that something the court could consider? If he had just not testified and let the people try to meet their burden of proof, that's one thing, but he gets up there and testifies apparently falsely that he wasn't even there. Shouldn't that factor into his punishment?
That particular issue was not mentioned or raised at the trial court level. So I honestly don't know how to answer that. He certainly, that could have been something that the people considered prosecuting him on, and it could be taken into account.
Well, it's not necessarily, my question on that would be not necessarily that the people were going to prosecute him on that or prosecute the mother, right? I mean, he submitted his mother.
Prosecute the mother.
Right, for perjury.
Perjury.
But that was information that the trial judge, the sentencing judge, didn't have at the time the plea offers were made, right? Because the plea offers are made before trial starts, then trial starts, and then,
Yes, Your Honor.
and then now you have this, potentially perjured testimony, and he's submitting his mother's testimony to try and explain that he wasn't there. So I'm saying, my question is it fair for the trial judge to consider what happened before him or her at trial for purposes of sentencing?
Yes, it certainly is, Your Honor.
Okay, thank you.
Thank you.
Thank you, Counsel.
Morning, Honors. Brad Osler for the people. May it please the court. I submit that the evidence was sufficient as far as the defendant being aided by another, as the panel hinted at. The co-defendant was present. He was relatively close by.
Right, I agree with you on the close by, and he was present, but the aided part is a little concerning to me. The co-defendant, Mr. Herzog, testified, if I'm not mistaken, that this was all a surprise to him. He's just hanging out with the defendant, they're riding bikes, and that out of the blue, the defendant robs this guy. So in other words, Mr. Herzog was just there, and he didn't know what was going to happen. He didn't help him intentionally. Can you, is that enough? Can the person who's actually present aid and abet without even knowing the robbery's going on?
Sure, I'll address that under the facts of this case, I think, in 2 ways. Number one being that the defendant was acquitted of the first-in-time robbery of the victim, Green.
Yeah.
The fact that that event occurred, now I know I believe defendant testified that, or the co-defendant testified that he didn't quite see exactly what happened, but nonetheless, that event happened. The lottery tickets were in the backpack later on, so, I think we have, some proof that some event occurred there. The second event was Herzog testified about the exact details of what happened. I think he had some idea of what the defendant was going to be doing, and the fact that he was close by is in fact enough.
He testified that he knew that a robbery was going down, or did he testify that this was all a surprise to him?
I think, if I recall, I think he testified certainly with respect to the first robbery.
No, I'm
that it
talking
was
about
a
King,
surprise.
because King's the one he's convicted on. Did he testify that he knew the defendant was going to rob King?
I don't believe he ever said that he knew that was the plan, no.
I think he said he didn't realize that. So, for example, if you rob Mr. Dunn right now, and I'm here, I'm actually present, but I don't have any idea you're going to rob him, is that rob too because I'm actually present?
No, and I would distinguish this case, however, based not only on the previous act that took place, but looking at the case law that we have that talks about there not being a requirement of shared intent. These, I'm going outside the Fourth Department a little bit here, but there are cases from the First and Third that discuss the idea of say a getaway driver that's nearby, isn't directly participating in the robbery.
I understand that, because that person is aiding as far as driving the person away, but here, and I don't believe for a minute that Herzog didn't know what was going on. Just put that out there. I mean, this was obviously they were working together. But the evidence was Herzog, to the jury, was that Herzog said he didn't know what was going on. But is it enough that the victim, does that even matter? The victim sees two people, he's more scared by two people than he would be by one person. Is that enough? Or could it just be some random guy standing in close proximity and that's robbery too?
I think we'd have to distinguish Herzog from being just a random nearby person.
I know, Counselor, I think what it boils down to, the analysis would be different. If you're trying to convict Herzog, who just happens to be an innocent bystander, he has to participate in it. But this situation is the opposite, is that what was was the victim of the crime? Did he see two bodies there? Was the guy in close proximity? And the argument appears to be that whether he knew or didn't know, he was there with the guy, and the fact that there was two people, or three people, or four people changes the scenario than a one-on-one. See, I look at it differently as to it may be more difficult to convict Herzog on those facts, unaware his buddy's going to commit a robbery, as opposed to this. And I think that, as Justice Lynn is getting to, is whether or not does he have to be a participant in it in order for him to be considered aiding.
Correct.
And obviously, there's nothing in the record that he was a pure participant under Section 20.
Correct, that's true. He did not, forcefully take the property. He did, however, sort of linger nearby while this was happening.
His aiding was just his mere presence. And and the legal question, I don't know what the answer is, but can you unwittingly aid a robbery just by standing there, not knowing what's going on?
Not completely unwittingly, but I wouldn't suggest, I don't think the evidence suggests that Herzog was. And going slightly past the robbery, he aided afterwards, and retention, or aiding in the retention of the proceeds of the robbery can also be enough to find that somebody aided. And he certainly did that. He took the book bag, they split the proceeds later on. They, to a certain extent, fled the scene together on their bikes. I think there's plenty of evidence that it's certainly enough under the sufficiency standard.
There's enough, in other words, to say that Herzog's testimony that he didn't know what was going on is not true. There's other evidence that he was in on it, sharing in the proceeds, and therefore we can say he intentionally aided.
I think that is very much the case, and even in light of his testimony that he didn't know what was going on, I think his proximity and the fact that the rest of the evidence that he was tagging along with the defendant, I think that's enough.
To the attempted.
That's also true, yes. So I think in light of everything, we do have certainly sufficient evidence that he did aid. I'll note quickly, just with regard to the ineffective assistance, I'd suggest that the defense counsel had a reason for bringing up the criminal impersonation. I believe this is laid out in my brief. Part of his alibi was that he wouldn't talk to the police. The defendant wouldn't talk to the police. He wouldn't have given his phone number to a certain police officer that testified that she did, in fact, collect it from him. to kind of establish the defendant's credibility, he had to talk about that whole event where he was arrested for criminal impersonation. And that involved discussing what he did or did not discuss with the police officer that testified in this trial. So there was actually a strategy involved, unlike the Fourth Department case, the Webb case, where it's not clear that counsel had any sort of strategy in terms of breaching maybe Sandoval issues. The counsel here, there was a clear reason for doing this, and it was in fact to establish the credibility of defendant and his alibi defense.
How about the sentence? He was offered 7 for 2 robberies. He gets convicted of 1. He ends up with 14. It looks like he has a prior robbery. He got probation, so it doesn't look like there was no weapon involved here. Nobody got hurt. He stole $85 in a cell phone. Granted, he's got to go away for a long time, but 14 years for this kid seems a little...
The only thing I can point to, Judge, is his history, and it's not a good one. He did have a prior felony conviction. I think he had 6 arrests. He had 3 different stints on probation. Obviously was not doing well on probation. I think that speaks volumes for why the court sentenced him as it did, and then also to a certain extent, seeing his conduct in the trial, which was, I think, perhaps viewed as slightly disrespectful of authority, as his behavior had been up to that point.
Thank you, counsel.
Thank you, Judge.
Case number 7, People versus Shorter.
Good morning, Your Honors. May it please the Court. Kristen McDermott on behalf of Wayne Shorter. The lower court in this case abused its discretion by denying Mr. Shorter's motion to withdraw his plea without any inquiry at all. Mr. Shorter's complaints were not patently insufficient to permit them to be denied without an inquiry. He said that he was confused when he was taking the plea, he wasn't satisfied with his attorney, he felt forced to take the plea because his attorney wasn't going to fight for him, and that he wasn't actually guilty of these charges. This required the court to at least ask some questions.
So he was able to set forth his argument as to why the court should allow him to withdraw his plea, correct?
That's correct.
And the court could also consider the actual plea itself and the circumstances of the plea and the defendant's answers to its questions, correct?
Correct. And the court relied entirely on the plea transcript. But that would essentially require the defendant to make those same allegations at the time of the plea to even get an inquiry, and that's really not what the case law says. Under Mitchell, if the defendant is raising new allegations later after the plea, there should at least be a limited inquiry into those allegations. And I would say particularly so here because the complaints that he was making implicated a breakdown of the attorney-client relationship.
Well, his complaint was that, maybe you're right, but I didn't read it, he was saying he was not guilty. He was saying that the stop was unlawful. That, I mean, this is his 3rd DWI in a short period of time. And I think what he was saying is that he wanted his lawyer at the suppression hearing to argue that the police officer didn't have reason to pull him over. And the lawyer says, well, he's going to testify that you failed to signal a left turn. And the lawyer says to him, well, it's a tough sell convincing the judge that the police officer's lying. That's the complaint of the lawyer, of your client, about the lawyer. Is that the extent of it? Am I correct in all that?
That's part of it. I don't think it's the extent of it. He also did actually say he was not guilty of the crime, but that was his main complaint about his attorney.
Yeah, the argument of he was coerced by his attorney. But going back to begin with, Justice Troutman brought up is the fact is that it isn't unusual in the sense that he was actually allowed to make his own motion. He placed on the record what he thought was why he should be able to withdraw his plea. And the court listened to him, and I don't think you disagree that if the court finds it's patently insufficient, the court is not required to make any inquiry.
Correct.
So really what it boils down to here is that whether or not we have to look at the motion being made and whether or not the court abuses discretion by not asking the questions. That's really what it boils down to.
That's correct. And I would say that these were not patently insufficient allegations, and it's not too much to ask the court to just ask a few questions about them. Thank you.
Thank you, counsel.
Good morning, Your Honors. Ken Tyler for the people. I would submit to you that the inquiry was appropriate with respect in its proportionality to the allegations contained in his letter asking to withdraw his guilty plea. As Justice Lindley pointed out, his allegation was that defense counsel told him, well, you could be convicted or lose your suppression motion on even falsified testimony, and that's exactly what the thrust of it. He didn't like that answer.
There was nothing incorrect about that answer. Look, this court bent over backwards for the defendant. He gave him 3 lawyers. 3 lawyers. He complained about each lawyer. The people wanted 2 to 6. The court nevertheless gave him concurrent 1.5 to 3 to probation. This court bent over backwards for this guy. And it doesn't seem as though there was any failure to give the guy his say about what his complaints were.
And not for nothing, this was not his first run into the criminal justice system. I don't think it would have honestly surprised him to learn that even if he disagreed with the officer's testimony, he could lose his suppression motion. Like you said, that's accurate advice. For all those reasons set forth in our brief, we'd ask you to affirm.
Thank you, counsel.
Thank you.
Case 8, People versus Simcoe.
Morning. May it please the court, Joe Frazier for Mr. Simcoe. I know my brief asked that the court remand for a hearing on all issues. I think that this court has the authority to divide up the issues. He's asking for really separate.
Counsel, let me ask you kind of a preliminary question, and I recognize it hasn't been brief, but I'd like to hear from both of you on this. Judiciary Law Section 14 says a judge shall not sit in any proceedings in which he was an attorney, and in this particular case, we've got the DA who signs the indictment on this case, if the record is accurate. And that DA then, it's right at the time the transition's taking place, as I understand it, the DA signs the indictment. It might even have been after he was elected to Supreme Court. And then the case is handled by that DA who now is a Supreme Court judge. Is this a case that was appropriately before Judge Murphy, and is this not a case that should be sent back and handled by another judge?
So I looked at that. I didn't brief it because it wasn't part of the motion, the 440 motion that was raised. But the other judge, the law clerk, was in the defender's office at the time, and I think that might have been an issue because our office represented Mr. Simcoe also on the last 440 that came to this court. But yes, I don't know why Judge Murphy ended up with this other than that reason. But
under judiciary law, should not have Judge Murphy recused on this and sent the case to another judge?
It seems that would be the case.
Yeah.
But you didn't raise it in your brief because it wasn't preserved? Is that?
It wasn't raised by the defendant in this 440 motion.
I thought he made reference to it in the 440.
I don't recall that.
Yeah, and the pro se, there was a pro se supplemental brief. I thought that it might have been referenced, but okay. Any further, counsel?
Just on the issue of ineffective assistance of counsel, Judge Murphy's decision was very conclusory. It really didn't mention the issue of ineffective assistance of counsel, except to say that he could have raised it before. He did raise it once before, but it was on entirely different grounds. The existence of this note, it's not determined what defense counsel did, other than it looks like an investigator went out.
The existence of the note, are you referring to the note from the wife?
Correct.
The claimed note, and where she says, "I'm sorry this happened."
Well, we don't know what it says because the note was never obtained. The investigator.
How does that affect the attempted murder of a police officer?
Okay. It may not affect the attempted murder of the police officer if the finder of fact believes that the defendant made a stabbing motion with the knife, but it may affect the attempted murder of the wife.
But the police officer arrived at the time that this conduct was going on and found the wife in a certain state, correct?
Right. What the defendant's claim is that she was the initial aggressor in the fight. He had a defensive wound to his hand.
And the jury heard this claim of defense and could properly reject it.
Which she denied, but it would have been an entirely different case if they had this note that said, I'm sorry, I was the one that caused this. And in his motion papers, he is
What
saying.
established she said she caused it? Did
So-
she submit an affidavit saying she did that?
No, so they got testimony from her in the subsequent federal trial where she gives equivocating testimony and says about the existence of the note, I don't recall. She says, absolutely not, I do not recall, in sum and substance.
Well, in essence, your argument here appears to be based upon the testimony that was gleaned during the federal trial from
With
police officers and the victims.
With respect to the newly discovered evidence, the appellant is saying that it's newly discovered evidence because they say things different than what they said at trial. But more specifically, with respect to ineffective assistance of counsel, it has to do with the note and what the wife says or doesn't say, and what defense counsel should have done once he knew that there was this note. There was two gentlemen that testified at to an investigator and said, we got these notes from the wife. She asked us to bring them to the jail. We couldn't give them to him, but we held them up to the window and he was able to read them. And he says that the note said that she took full responsibility.
No, it said that she said she was sorry that this happened. It doesn't necessarily absolve the defendant of any responsibility, but as Justice Troutman pointed out, I think you would concede, even if you're right on this, the ineffective claim, he's still convicted of attempted murder of the police officer. That has no effect on that count, right?
It has no effect on that count, the
Right,
note
okay,
itself.
so that count stands even if this apology note ineffective claim has merit. But what about Judge Murphy's ruling that he could and should have brought this in one of his many prior applications?
So it's a discretionary matter. Judge Murphy has the discretion to look at that. He's not required to deny the motion on that ground. The statute says he may deny the motion on that ground. But before he did that, he should at least look at the strength of the motion, whether there's.
Right, and we're talking about strength of the motion. The defendant testified at trial.
Correct.
If I'm not mistaken. He never testified. We had the direct appeals. I'm just going from memory, but I don't believe he ever testified that my wife wrote me an apology note and absolved me of all responsibility and took the blame for everything. He didn't mention anything about a note, and he's the one who was shown to.
Yeah, and I don't know what the reason for that was at the trial.
Maybe because it never happened.
Well, we've got the statements by the two gentlemen who said they had the note. And our point is, I mean, defense counsel never
But the point is that given an opportunity to testify, which was his right, he testified at trial. Certainly, he was in a position at that point to state anything he had that was relevant, including the existence of that note and the contents he claims existed.
And I don't know that the defense attorney tried or did not try to do that. As I stand here, I don't know whether he
But
tried to
it's
get
tough
that
for it's tough for your client to argue, my lawyer was ineffective for failing to investigate a note that I didn't even mention during my testimony.
Well, this is pre-trial activity. What the defendant says is that the only thing his attorney told him was, we're not going to call these witnesses because they have a criminal record, which I think is a wholly insufficient reason, given that the complainant herself, the wife, had a criminal record, and this was a non-jury trial. There was going to be no great sting from finding out that there was a criminal record.
Counsel, let me ask you, I want to be clear on your position on this with respect to the Judicial Law Section 14 questions that I asked. If I understand what you're saying is you recognize that this was a problem and you chose not to brief it and you are thereby waiving it to the extent it's waivable?
No, Judge. I was not aware of the Judge Murphy issue. I was aware of the reason that it went to Judge Murphy was because Judge Speraza, Sheldon's clerk, had been in our office when the last 440 motion was appealed.
So this is new information to you with respect to the judge signing the indictment and also handling it, signing the indictment as DA and then
It
also
is.
handling it.
And I don't know if there was any discussion when he filed that motion.
To the extent that this, you would have an opportunity, if you asked for post-argument submissions, are you asking for that?
Certainly.
On that issue?
Certainly.
Only? Yeah. Okay, very good.
Thank you.
Counsel?
Morning, Your Honor. May it please the court, Tom Brand on behalf of the people. Speaking about the note, as the court has recognized, this was not a recantation note. This was a note that said that she loved him still and she's sorry for what happened. That's a common, unfortunately, dynamic that we have that we see in victims of domestic violence, and that's not a recantation. That's not a contravention of her testimony at trial as to what the defendant did to him and how it was done to him, done to her and how it was done to her. And the defendant's attorney had that investigation ahead of time. He sent the investigator out ahead of time and knew that we had this she's sorry for what had happened statement. But that's all it was. It's not an apology and it's not a recantation. And that's why she's not, that's why there's no discussion at the trial about this, because the defendant's making this up out of whole cloth now. There was nothing back then for the attorney to do. He looked at it, he tried to follow it, and there was nothing there.
And it could have been, she was sorry that the defendant smashed her head repeatedly against the floor and almost killed her and then bit off her lip to the point where his lip was in his mouth. She could have been sorry that that happened.
Absolutely, and that's what this court found 10 years ago. That's the finding of facts by this court 10 years ago is the proof at this trial. All those things occurred. And, but again, that's not, unfortunately, it's not an uncommon dynamic to have that situation. And that's not a recantation and that's not a contravention. Now, for turning to the issue that hasn't been briefed, raised, or anything else, and so I'm at sea as well as Mr. Frazier on this.
And counsel, I recognize that when I asked that question. That's why I'm offering counsel an opportunity for post-argument submission if you'd wish.
And I'm not, I don't have the judiciary law at my beck and call, but I do know that for a lot of those cases that were coming up, there was usually some colloquy also between the court and defense counsel as to the judge handling the case. And it may be that there's some of that out there also. I don't know. I'm not saying that 14 can be waived. Maybe it can't.
It can't be waived.
Can't
but,
be waived,
I mean,
no.
I don't think anyone's suggesting that if Judge Murphy was disqualified, the defendant's motion is granted. It would just be, it's null and void, and it goes to another judge who has no history with the case. And then you make all your arguments as to why the motion should be denied.
Yeah. Yes, I mean.
Kind of like Groundhog Day, you know?
Start.
Kind of like Groundhog Day, you're going to maybe repeat it.
All right. But we'll submit anything in opposition that Mr. Frazier chooses to submit, and thank you for the court's.
Thank you, counsel. Case number 9, People versus Dozier.
Good morning, Your Honors. May it please the court. Unless the court prefers that I do otherwise, I thought that I would submit on point 3, the excessive sentence point, and focus today on points 1 and 2, respectively, the appeal waiver and the issue of the inadequacy of the record. With regard to the appeal waiver, just briefly for the first couple of these, the court's explanation of the appeal waiver was tautological, telling the defendant this case will be over and it will go no further.
Doesn't People versus Thomas from the Court of Appeals resolve point 1?
If the court takes that position, then I would gratefully accept that. And
well, I don't speak for the court, but it seems as though that greatly strengthens your argument. For me, I don't need to hear any more, but I'm only 1 of 5.
Oh, well, thank you very much.
Since one of those 2 cases came from the 4th, I think we're kind of bound by it.
Thank you very much, Your Honor.
With respect to the adequacy of the record,
yes, sir.
You're claiming that the record on appeal is not complete or sufficient for our review because of the absence of some alleged letters.
Yes, Your Honor, and I would submit that the record, in the first place, I understand that it is not something where I would have to absolutely disprove the possibility that the court would just not respond to counsel misrepresenting the contents of the record, even if it is possible.
Has it been established that they exist by direct evidence, that is, by the writers themselves?
Well, I'm not sure exactly what Your Honor means. Mr.
How do we
Dozier-
know these letters exist?
The evidence consists of the following, aside from what was mentioned directly in the motion. On page 4 of the pre-sentence report, it was mentioned that in the...
That was my point, hearsay.
Well,
Probation
pre-sentence-
officer says they exist, the attorney says they exist, but there are no affidavits from the purported writers of same.
Well, Your Honor, I would make a couple of points about that. The first is that I would submit that it would not be jurisdictionally proper for this court to affirm on that basis because there is no indication that the lower court based its denial of the motion on that ground, and indeed, at page 11 of the transcript of the proceeding where the argument was held, the court indicated that it was denying the motion based on the arguments that were made by the people, and the people were not arguing that the motion is facially insufficient because it's hearsay. What the people were saying was, and I would mention further that we don't even know, by the way, that it was hearsay when defense counsel was saying in court, I know the court received letters.
Why is the record insufficient?
Well, I don't, because these, what remains to be cited in the excessive sentence point without the letters is extremely meager. And letters that are submitted.
So your argument is the argument for excessive sentence would be stronger if the purported letters were included in the record?
I would put it much more strongly than that, Your Honor, but I would say that that is proximate to what I'm arguing.
Couldn't that information be contained elsewhere, like the pre-sentence report?
I don't believe that it in fact was. But again, I would emphasize that in their motion, which the court adopted in its decision denying, in the people's motion response, which the court adopted in denying my motion, that was not one of the arguments that they were making against it. They were denying that the letters were even received or that they were sent.
Right.
Well,
So
going back to the question Judge Trott was asking, and like I said, from the beginning, obviously nobody can find the letters. We agree with that. So by providing the court down below with affidavits from the individual who provided the letters, we now have a record, we now have those affidavits. The court then has it before him. It may recognize, yeah, this was said, but if not, those are part of the record. You would agree with that if they were affidavits, and they'd come up to us, and then we can look at those affidavits and those that you're alleging are in the record and determine whether or not it was harsh and excessive.
I do understand that, Your Honor, but I would say a couple of things about that. First, inasmuch as the people did not protest, these are insufficient because you did not produce this type of evidence that the letters existed. I mean, there was also my affirmation in which I relayed what was said to me. Mr. Shaw, he had told me, yes, he sent a letter, or that he had written a letter, rather, but that he doesn't have a copy of it. But setting that aside.
So all the defendant was required to do was to assert that they existed and
well,
were mailed.
It was more than that, Your Honor, though, because defense counsel is saying right there in court, I know that the court received letters from the mother and the aunt and perhaps some other people.
How does he know?
I don't know how he knew, Your Honor, but it would be.
Going back to Justice Trump, I understand it's hearsay, not argument, but once again, without any affidavit, if you spoke to someone and you have an affidavit, as opposed to, you see, he says he knows. How does he know? He doesn't tell the court, I know because I have affidavits. And if he says, I know because I spoke to so-and-so, aren't we running into that hearsay again?
Your Honor, I think that it's more than just that, though. It's also the fact that at the time that he said that, the court did not say, what are you talking about? I didn't get any letters. That, even if it's not 0%.
The court didn't say anything.
Yes, that's right. But
You're saying it wasn't incumbent upon the defense or anyone to ascertain whether in fact the court actually received same and considered them?
Your Honor, I don't think when defense counsel is saying, I know the court received letters, and I don't think that it's necessarily inappropriate for counsel, if he does indeed know, if the court did in fact have the letters, then specifying, I can see them right on the desk in chambers or something like that.
Well, he does say this. The court says, so I disagree with you saying that there must have been letters. And he concludes with, I don't think there were any letters.
He did, Your Honor, but it was not based on recollection because he was, so far as the transcript of that proceeding indicates, because what he was saying previously was that I have no recollection. He didn't subsequently say, well, now actually I do have a recollection and I specifically remember that I absolutely got no letters.
What you want is a reconstruction hearing.
Yes, Your Honor.
And so what would happen at the reconstruction hearing?
Well, at the reconstruction...
because this is an odd situation, that most reconstruction hearings, you're trying to recreate something that wasn't captured in a record, but everything here is in the control of your client. Is a letter from his mother, a letter from his aunt, a letter from him, a letter from his employer. And why not just go back to those people and say, could you write another letter with the same things, and we'll give it to the court?
Well, I would say a couple of things about that, Your Honor. That could be done at the reconstruction hearing, but I would submit that under CPL 470.15 sub 1, it would not be a proper basis to affirm on the ground that I did not supply that for the following reasons. There isn't any indication in that the court was basing its denial of that on the fact that I did not provide that specific evidence for what I was saying, and the people, if they had argued that.
So at this hearing that you want us to hold, these folks would have to testify, this is what my letter said, generally.
Or I could have them provide affidavits, and with the specific instruction that it is not to be.
Those witnesses have no idea if they were received by the court, because as I understand it, they gave them to your client, and your client then from jail sent them to the court.
Gave them to the client's mother to the client, and then from the client to the court.
Yeah, I don't know, but it's an odd situation, and I think you recognize in your brief, there's no cases on something like this, but your client shot a person twice at close range and attempted to kill him, and he was 30 years old, wasn't a youthful indiscretion, and he gets 10 years. We just heard about a guy earlier this morning, he got 14 years, 21-year-old kid for just saying, give me your money without any weapons, didn't hurt the guy, and he got 14 years. Your client shoots somebody twice, but I guess you're saying, for us to say whether it's harsh or excessive, we really need to see those letters.
Yes, Your Honor.
However slim the chances it's going to influence us.
And if I might please further add, with respect to the people not having argued this, the people and appellate courts are constantly saying in many decisions, because defense counsel did not say, well, you didn't put in enough foundation for this or that, the people could have corrected that if only the issue had been protested. Aside from the CPL 470.15 sub 1 point, I would say, if this issue had been protested in the proceedings below, I would have promptly corrected that by saying, okay, here is what I'm speaking to them. They're telling me affidavits from them, absolutely anything. Because
So
that
are you
issue
saying
was,
the people didn't protest that? I don't know what letters you're talking about, because the people would have had the right to see them also.
oh, yes, absolutely, Your Honor. But it's beyond that. It's the LaFontaine issue from them, from the court not having decided on that ground, and also the fact that if that argument had been made by the people, I would have promptly corrected that problem. But it just was not raised. And I would say just as often those kinds of considerations hurt the defense when they raise a new issue on appeal, so also should it be here, even apart from the jurisdictional problem.
You know how infrequently we modify a negotiated sentence.
I do understand that, Your Honor, yes.
You're going through a lot of work, and I give you credit. I mean, you're going through a lot of work, motions and appeals, to try to get us to consider an issue that you know has a 0.1% chance of success. So I give you credit for your effort. I'm not sure it's going anywhere long term, even if you win here today.
I would just submit that in the absence of the contents of the letters from the record, it really is not possible to determine that. There's no way it could make a difference. I do understand. Very serious crime. The sentence was significantly below the maximum, nearer the lower than the maximum. I do understand that. But
And you're arguing it was the court's responsibility to keep those letters so that they could be held for review later.
Yes, Your Honor, and I would ask, regardless of what ruling this court makes on this issue, because this is a problem that has come up repeatedly in cases that I've had and that colleagues have had, I would ask the court respectfully to urge the lower courts to hold on to records that could be significant for issues that could be reasonably expected to be raised on appeal.
Thank you, counsel.
Thank you, Your Honors.
May it please the court. I also appreciate Mr. Williams' effort on behalf of his client here on this issue. I think in this case, at least as far as what the plea court was inclined to do, the letters wouldn't have mattered. And I don't think that's a problem, in fact, because the plea court expressed...
But you do agree it is the court's responsibility to maintain the records that are considered below?
Yes, Judge. If we can assume that the court did receive those letters, absolutely. I agree with that. I think as far as what that court did, I think the letters ultimately were not relevant in this sense. That it wouldn't have mattered because the court had expressed already an aversion to the crime. and it was morally constrained.
As Mr. Williams explains in detail, it's not whether the trial judge would have changed the sentence, it's whether we would modify it in the interest of justice. And he's saying we need to see those letters. Maybe we'll feel really bad for the guy and say, well, you get less than 10 years for shooting a guy at point blank range twice and trying to kill him.
And, Your Honor, I didn't argue that. And the reason I didn't argue that is because that's entirely within this court's purview. I stand on the facts of the case as far as they were elicited at the plea, the defendant's background, and arguing that the plea was appropriate. But I'm sorry, the sentence was appropriate. But I'm happy to defer to the court as to review and its disposition on the sentence.
Thank you, counsel.
Thank you.
Case number 10, McMiller versus Frank.
Good morning, Your Honors.
Well, we wait until everybody's situated. All right, thank you, counsel. Please proceed.
May it please the court again, Kristen McDermott on behalf of the father, Anthony. In this case, the mother brought the child to live in North Carolina in violation of a court order without asking the court for...
But we understand that, right? So there was no application to relocate with the child, right? There was even, I think, if I understand the record correctly, there was no notice to the father that that was taking place. In fact, I think at some point the father was waiting for the child to get off the bus, and the child just doesn't appear, and that's the beginning of him knowing that the child has been relocated out of state, right?
That's correct.
So let's assume, okay, that's fine, that happened, that's wrong. We still have to look at the best interest of the child, right? We're not looking at punishing a parent for doing what was wrong.
That's true. The best interest of the child is always the primary consideration, and we're not asking that Natasha be punished. We're simply asking that she not gain an enormous advantage at this hearing as a result of violating the court order. The way that the court did this only encourages parents to do exactly what Natasha did here, which is abscond with children in violation of court order.
But didn't the court consider the relevant facts as to the circumstances of each parent? The reason that she was relocating? It wasn't for a paramour, it was for better opportunities.
Respectfully, Your Honor, it was not for better opportunities. When she left to go to New York, she was very clear that she said, I just didn't want to live in New York anymore. She was quitting a job that she had for 15 years to go to a place...
for North Carolina?
Yes, she was quitting a job in New York that she had for 15 years to go down to North Carolina where she had no job lined up. This job that the court and the attorney for the child relied on very heavily, it was something that she didn't get until March, which was 6 months after the child had been moved down to North Carolina.
You know what's interesting, and I think where your hurdle, at least for me, begins, the court finds, it's the court's words, confusing, the father's testimony confusing, hard to follow, lacking in credibility, and it goes on. I mean, it appears to me that the court discounted your client's testimony. You know, it's a credibility issue, and that's really part and parcel of the basis of the court's determination. He said what a great father, what he did, how he did things. The court didn't buy it.
That's true that was the credibility determination the court made, but even accepting that credibility determination, the mother in this case didn't meet her burden. Because both parents, even the mother, admitted that there was a relationship here between the father and child. She said that the visitation was somewhat inconsistent and the court believed her, but the child was with his father. They did things together. They read together. They went to the library. They went to the boxing gym. This was an involved parent.
But as long as the court takes into consideration those factors, in other words, I think that, you know, the worry that this is going to encourage other parents to do this kind of, you know, improper conduct is a legitimate and fair consideration. But as long as the court is taking into consideration that and saying, and assessing, is this an alienation? In other words, is this an attempt by one parent to alienate the other parent from the child? That certainly should get great weight, right, by the court in assessing whether or not she should move back to New York. And so you want us to look at this record and say, and determine whether or not the court did that assessment and did it appropriately.
Correct, because we're arguing that the court improperly evaluated these factors. The court looked at what was happening at the time of the hearing.
Yeah, you want us to go back to view this to the scope of just
what took place before the relocation and whether or not, and not utilize her conduct of leaving wrongfully and put that towards the benefit as opposed to the pre. So you want us to take a look at the snapshot pre-relocation because you do recognize post-relocation may be a little more difficult for you. The pre-location may be a little bit stronger for you.
That's correct, although even...
And are you arguing that the court didn't give sufficient weight to what happened with respect to the relocation without permission?
Yes, absolutely. I would just point out that this court has said that absconding with a child raises this strong probability that the parent is unfit to continue acting as the custodial parent. And the lower court really didn't seem to give proper weight to that factor, which is a really, really big problem here. I would point out, though, even looking at these factors exactly as the lower court looked at them at the time of the hearing, the mother still didn't meet her burden because, you know, the court relied heavily on her job, that she was making a few more dollars an hour down in North Carolina, but the record also showed that she had more expenses down in North Carolina that would have completely offset any raise that she had. All the evidence that she put forth about the child being in a better school was mostly just opinion testimony. She didn't give any documentation to show that this was better for the child.
There's testimony about family support being more substantial down there for the child, for her family.
For her family, it was her sister and her brother-in-law, and there were some cousins. I would point out, however, that one, the child was being alienated from a bunch of other family that still lived up in New York, both on the mother and the father's side. And despite this testimony about this family support...
When you say alienated, are you saying because of being removed from New York?
Correct.
Okay, you're not saying she actively prevented contact with other family or discouraged contact with the other side?
There's no evidence of that, no. But I would also point out that down in North Carolina, the child was spending 12 and a half more hours a week in childcare away from his family than he was spending in New York. And the really crucial factor to both of these things is that the mother never testified that she attempted to find a better job or find a better school in Onondaga County. And that is a requirement for relocation. Before you can show that you have to go to 700 miles away for a better job and a better school, you have to at least try to find one near the other parent where the parent can have visitation with a child.
That's an important factor, but your client never paid child support. You didn't have any contact with the child for the first 6 years of her life, I think. The mother was the sole provider for this child. Yes, going to North Carolina without notice, that's a factor that militates in favor of your client, but there's a lot of stuff on the other side as well.
Understandable, but this court can order to the child brought back up to New York and still be with the mother. And that would be the best case scenario. The mother would still be the primary caretaker and he would have access to his father. So, you know, that could be the best of both worlds if the court feels that the child should still be with the mother. And I would also just quickly point out that the reason that there isn't any evidence on the record of what happened before the child was 6 years old is because my client was precluded from putting that on the record because the attorney for the child objected. So anything that happened in that time period, I believe, could not fairly be held against him.
Thank you, counsel.
Thank you.
Morning, Andrew Greenberg, attorney for the child. We are seeking an affirmance here. This move is in the best interests of my client. We do agree, let me start there, we do agree that some change in the language in the order for the visitation would be appropriate. There was an insertion of a month for a visitation period, which there is no school vacation.
It has to do with the school breaks, and there was some confusion as to when the break
Correct.
occurred, North Carolina versus New York?
Correct. When the order was drafted, the drafter and the court in signing off on it assumed that there was a February vacation when there in fact is not a February vacation in the school that my client attends. And the appellants in the reply brief suggest, actually, what I think is the best, better than my suggested improvement to the language. They have a suggestion for a very clear, simple modification that I think would be in my client's best interest, and we would certainly agree with that in terms of modifying the visitation. In all the respects, we're seeking an affirmance here. This is not a case about unfitness. Justice Whalen, when you immediately say that it's all about the best interest, that's the focus here. I think actually the family court referee did a phenomenal job of staying focused on that. That's what it's all about. And if the focus is on the best interest, the tropea factors were covered by the court. The record fully supports that there was educational improvement, that there was family support improvement, emotional improvement, and in every respect, my client's life was improved by this move. The final thing I would suggest is that what the cases require is not that there not be a disruption to visitation. Visitation with the father is important. But here, the issue, really the only contested issue on the facts was what was the visitation like before the move. The court found that the father was incredible on that visitation was sporadic, and that was the starting point. And here the court's left with only two options. The court's left with the option of having the child stay down with the mother, where he'll have been for 2.5 years, and visit the father, or the court could order on a modification that the child live with the father. The court cannot order the mother to return. So in any event, there is going to be long-distance visitation for this child, and the question is, where's the child better off, with the mother or the father? And I think the record clearly supports the child is better off with the mother.
Thank you, counsel.
Thank you.
Ms. Frank, are you Natasha Frank?
Yes, sir.
You were scheduled to argue. Do you want to be heard?
Yes, sir. Good morning. I didn't move without asking permission of the court, but I asked the court leniency because at the time that I moved, I lost my mother. And I asked Anthony to watch the child while I took care of my mother. And he did it for 2 weeks, and then the child didn't want to go back, and I was worried about my mother, who eventually died of colon cancer, and I was a sole caretaker. I couldn't take care of my mother and take care of Andre. So my sister said she'll take care of him, and once my mother died and I took care of all her stuff, I just went with my sister, and I started life in North Carolina. And I do apologize to the court about the way I did it. I knew it was wrong, but at the time I lost my best friend and I did what I did. But Andre is doing much better. If they pull his school records, he's perfect attendance. He's now on the honor roll. He doesn't get in trouble anymore. And life is better for him in North Carolina.
Thank you, Ms. Frank. Case number 11, Green versus Bolton.
May it please the court, Dennis Kitchen for the respondent. It appears that...
Excuse me, counsel?
Al Green of the AFC.
Very good. Why don't you have a seat up front where counsel sit?
It appears that the appellant's counsel is not appeared for argument. Therefore, I see no reason to prolong my own argument. The only point, first of all, is that I understand that the position of the AFC has changed. I'll leave it to Mr. Green to explain that. And just to address the initial point of the appellant's brief, that there was interference on the part of the mother with the visitation and contact between father and son. This is not an interference case. It was never alleged at the beginning. There was no evidence really that went to that point or was pursued in that
Isn't this
fashion.
the instance where the mother was responsible for transporting the child for visitation with the father?
She handled all of the transportation, and the father had regular visitation on an almost weekly basis for extended weekends, and
And this was courtesy of the mother's...
They didn't communicate, but she facilitated the
Correct.
visitation, nonetheless.
Transportation was lacking, but, or rather, communication was lacking, but not transportation. And I'll rely on my brief for the balance of this. Thank you, counsel.
May it please the court, my usual practice as an AFC is to talk to my client when I get the assignment and then talk to him shortly before I appear the court, in front of the court, to make sure his position hasn't changed. In this case, for the first time, I have a 15-year-old client who changed his mind and changed his position on where he wanted to live. He moved into a new school, he's on the football team, he's on the wrestling team, and he's got himself a little girlfriend. When I talked to Duriel, he said he wanted to stay with Mom, so I would urge the court to affirm the lower court decision.
Thank you, counsel. Case number 13, Barbeau versus Village of Leroy. Proceed, counsel.
Good morning. May it please the court, Amy Kendall for the appellants. The McQuillan defendants didn't raise a lack of standing defense with respect to either the second or third causes of action in the hybrid petition complaint, and therefore they waived the defense. For that reason, the lower court should not have dismissed the plaintiff's second and third causes of action. The village, which was another respondent in the case, was not involved in the second cause of action for nuisance. It wasn't a party to that cause of action, and it had no authority to assert a standing defense on the McQuillan defendants' behalf. With respect to the third cause of action, the McQuillan defendants also, there again, did not assert a standing defense. And while arguably the village could assert a standing defense to the extent that the third cause of action sought relief against the village, it couldn't assert it on McQuillan defendants' behalf. In the context of the lower court order, the order talks about, in fact, we had a dialogue about standing with respect to the first cause of action. If you look at the transcript of the hearing, there's no further discussion of standing with respect to either the second or the third causes of action. There was no reference of standing with respect to the declaratory judgment portion of the argument, which was 756 of the record. And there was no briefing on those issues. As you know, it was a hybrid complaint and petition. There are two separate courses that should have been taken. We were in front of the court with respect to the Article 78 portion of the matter. We had an argument, and that court made that decision. The first cause of action is not before the court now. But the plaintiffs did demonstrate that they had standing, even if it wasn't waived. The plaintiffs demonstrated that they had standing to bring a cause of action for nuisance for a violation of the village zoning law and for violation of the ZBA decision. So the plaintiffs are alleging a zoning violation, the ZBA, and a violation of the zoning law because the zoning law requires that actual access to the property be from the front of the property, which in this case is
the Robbins Road, right?
Yes, Your Honor.
Okay, now let me ask you this. Is it the Barbeau property that is right on the driveway that we're talking about? And what's the name of the road where the driveway comes off? Is it Hopkins?
Fillmore.
Oh, Fillmore.
Fillmore.
And so the driveway that comes off Fillmore, that's where the Barbeau property is located, right?
Yes,
so
Your
any
Honor.
traffic going up and down that road, it seems to me, would be something, and I think it was Barbeau that was keeping track of the
Yes, Your Honor.
the use of that road, right? Address the other plaintiffs, though, in terms of how are they injured in this? In other words, they're not on the road that we're talking about. They're not subject to the kind of constant driving, or constant's the wrong word, but the driving up and down that road. They're located, I think, south of the property, at least some of them. And I'm not sure that the record reflects how they get standing in this case. Do they have to show an injury? And if they do, what is the injury?
So this goes to the Bart's litigation. Some of the plaintiffs were involved, or their spouses were involved in the Bart's litigation, and the impetus for one of the impetuses for that litigation was this storage building, which is right off of Barbeau's property. And the neighbors were basically concerned about setbacks, proper setbacks in their subdivision. And, you know, with having basically an additional road going to potentially another subdivision. So that was the impetus for that. So
they're saying even though the setback isn't an encroachment upon their property, it's an encroachment upon a neighbor's property, and therefore that's enough of an injury to them to give them standing. That's what you're telling us.
Well, and that really each of the other plaintiffs have been in front of the zoning board, been required to get variances for different items, and they expect that in purchasing in the subdivision, they expected that they would have the ability to enforce the zoning law. The village's decision not to enforce the zoning law is, of course, one of the issues that has prompted this litigation.
I understand. Thank you.
And just, there's no question of fact here. The McQuillan defendants are violating the ZBA decision, they're violating the zoning law, and they freely admit it. They don't even deny it. The plaintiffs have demonstrated that they are both proximately related to the driveway, and that their interest is within the zone of interest contemplated by both the zoning law and the zoning board of the ZBA decision. Plaintiffs demonstrated through the record that there were both aesthetic harms and harms related to the amount of traffic going down this driveway. And really, we're talking about a driveway, but it's more of a road because construction vehicles are going back and forth. There's a business running in and out of there. There's FedEx delivery trucks. If it was a driveway, the FedEx delivery trucks wouldn't be running down the driveway. It could have been a UPS truck as well. Further, Barbeau is harmed because if the driveway is the actual access to the property, then the storage building should have been set further back because that would be the front of the property. But the front of the property, according to the village, is Robbins Road. And so either they can't have their cake and eat it too. They can either access the property and the storage building can stay in place, which is frankly the opposite of what we argued in the Bart's litigation, or they can use the driveway as access and the storage building needs to be moved according to the code. And I'll just note that you know, there's no public nuisance claim here. There was some mention of that in the defendant's brief, and just to sum up, an easement between two private parties does not magically grant a right to violate the law. And the way I talk about this is my client could have given his neighbor an easement to build a chemical factory on his property. That doesn't make it okay under the zoning law. And thank you.
Thank you, counsel.
Good morning, Christy DeFries. I represent Peter McQuillan, Judith McQuillan, and Circular Hill Incorporated. We are asking that the lower court's order be affirmed with respect to the McQuillan defendants. On the standing issue, the McQuillan defendants did interpose an affirmative defense of standing in their answer. That's in the record at page 345.
Was that standing relative only to the trial court case, or the justice court case? Not with respect to the second and third cause of action, right?
It discussed aggrievement, which is discussed with respect to the injunction cause of action, and it So I believe that it does.
So we'll take a look at the record, but you're saying that it does apply to all of the causes of action, not just the one as your opponent argues?
Correct. The headline for that affirmative defense does not say affirmative defense to Article 78 proceeding only, or something along those lines.
We'll read the body of it to determine whether or not it applies.
Sure, and that issue was only raised by the appellants in their reply brief, not in their main brief, so I
And
didn't.
with respect to a private nuisance, you're saying they don't have standing even with the location of their property?
Our argument is the court dismissed the nuisance cause of action on standing and because of the plaintiff's failure to show that there was any injury or harm to them with respect to the McQuillan's use of this driveway. So it is our position that they have not shown any harm. Their allegations in their complaint.
We're at a 3211 posture, correct?
Oh, it was 3212.
3212?
Correct.
Okay, on the thing that's standing. But the question I got is this: there appears to be case law that talks about when somebody's adjoining to a piece of property that, at this stage, you can infer that. You can infer some injury.
Sure, there is an allowable presumption of aggrievement in some cases, but that does not apply in all cases. That presumption arises with respect to if there is shown that there's a harm or injury to an entire neighborhood, that anyone that's in close proximity to that would also automatically be presumed.
Right, Barbu, he's right there.
Correct, but there hasn't been any showing of injury or harm to the neighborhood either. There's no, just this driveway also serves a duplex that's on the property that it goes over. There's no showing of harm stepping from, the plaintiff's claim is that the harm is the violation of the ZBA decision, and it's stepping over the property line from the property owned by Circular Hill to the McQuillan's primary residence. So there's been no differentiation between what.
But if you establish that they're standing because of the location of their property, it's a question of fact as to whether, at least arguably, there's interference with their enjoyment and comfort of their property. That would go to a trier of fact.
And the court held in the order that they did not demonstrate any harm or injury with respect to.
Which we could find contrary upon review of the record.
Correct. Even with respect to a nuisance cause of action, even if the nuisance per se doctrine applies, so that the nuisance per se doctrine applies, where there's been a violation of a law or statute, but that does not negate the requirement that there be harm or injury still.
And you don't disagree with respect to the original decision of the ZBA that it was not appealed with respect to which entrance your clients were to use?
We do not deny that it was not appealed. That's correct.
No, they just used the entrance or exit they wanted thereafter. They didn't comply with it. Do you disagree with that?
I do. I think that that the ZBA decision simply notes that the access will be from Robbins Road, and there is an access on Robbins Road. That's their primary driveway they use.
As I understand it, and correct me if I'm wrong, your argument is that the subsequent to the ZBA decision that arguably establishes the entrance from on Robbins Road, the easement was then granted. And it was that, and then it was, once the easement was granted, there's right of access over it, and that was not before the ZBA.
That was not before the ZBA, that's correct. If there are no further questions, thank you.
Thank you, counsel.
Good morning, Your Honors. James Wujik for the Village of Leroy. Just a couple points. I would ask that this tribunal affirm the lower court's ruling, as the lower court correctly determined that the appellants lack standing in the actions presented before the court. The village at all times acted legally. There was a complaint. The code enforcement officer, through his statutory authority, brought that before a justice court. It had to be moved around because of conflicts. That justice court dismissed the action, they filed their action in Supreme Court, which we opposed.
We have the record, Counsel. Let
Yeah.
me ask you this, and I wasn't able to find it, and I'm sure it's in the record somewhere, but I was curious as to whether or not the plaintiffs were all parties that had to be put on notice of the ZBA proceeding. In other words, under the rule, were all of the plaintiffs put on notice? And if so, isn't there a presumption that should be had that they have standing in this proceeding?
As far as I know, you're talking about the actual zoning board of appeals meeting?
Right, in other words, are they the kind of people that are affected according to the code? Are they affected to the point where they have to be put on notice that there was going to be?
Absolutely.
Yeah, and so if they are named people that are affected and have to be put on notice, shouldn't we presume that, isn't it appropriate to presume or at least give some presumption that they have proper standing?
Well, I can offer this for the court, that the village pursuant to the appropriate statutes put a public notice in the appropriate publication.
So the notice is a public notice to everybody. It's not individual letters going off to these particular plaintiffs.
Depending on what is before the ZBA, if there's an interested party within a certain area, you have to put those on. If somebody's asking for a variance.
I guess that's my question then. Was there a particular letter or notice that went out to these individual plaintiffs, or were they just put on notice through some publication?
That's not contained in the record. The only thing contained
I
in
was looking for that and I didn't see that. Okay.
Correct.
All right.
And in preparing the record pursuant to Article 78, council basically discussed and resolved that the actual decision itself was the only thing that needed to go in. And as far as, and really what happened is the village received a complaint, as I stated. They responded to it, appropriate to the statutes. The action was dismissed, and then this action commenced right after that. So that's where we've been for the many years with this instance. So from the village's perspective, they have to act, yes, in response to both the appellants, but also to the co-respondents as well, and they're kind of caught in the middle of it. So if there's no further questions, I would just ask that the lower court be affirmed.
Thank you, Counsel.
Thank you, Your Honor.
Case 14, 425 West Main Associates versus Selective Insurance Company.
Good morning, Elizabeth Kringle for the appellant. May it please the court. In this case, under both the policy of insurance and the appraisal statute contained in the insurance law, 3408C, 425 West Main is entitled to proceed to appraisal of the extent of the damages suffered in the March 2017
Is it a
wind event.
dispute between the petitioner and the insurance company over coverage?
There is, the insurance company has alleged certain coverage issues.
Your
However,
client wants the entire roof repaired?
Yes.
Or replaced?
Included within the more than $500,000 of damage is a replacement of the roof, which I believe is almost $350,000. The insurance company has admitted that a covered loss occurred. There is zero dispute that in March 2017...
That there is a covered loss, but a specific, more narrow loss. They took into consideration information of complaints, there were leakages, and they claimed that there was a lack of maintenance in the other areas that you seek recovered, and that the area that there was damage, there was a repair done such that they could not inspect.
That is the insurance company's position. However, they issued a coverage letter, and this is at page 292 of the record, on April 24th of 2017, where they did not reserve any rights, that in their opinion, they determined that the total covered damage from the wind event...
So what would the appraisal do here?
So
would it resolve everything?
No, appraisal would not. And to be clear, we are not arguing that the appraisal process makes any coverage determinations.
And that goes back to my question here. The way I read your papers is that your disagreement is the amount and the extent of damage, not the scope or coverage.
Correct.
Okay. They seem to be, and so what you're saying is that since they've agreed that a portion of the building, small portion of the building, they provided coverage for. They're denying coverage on the other ones based upon a wear and tear, rust, corrosion, deterioration that occurred within 14 days. Now, if you're asking the court to send it back for an appraisal just for that limited portion on what you say the value was, but when I look at your papers, it appears that you're asking the appraisal to determine the whole complaint, the whole ball of wax. Well, when we start going outside that limited portion, aren't we dealing with coverage issues, as Justice Trautman pointed out, as opposed to determining the damage? Because 340, 3408C, where you disagree on the value, loss or damage or amount of loss or damage, that's where it's applicable. But it doesn't be applicable, but it doesn't apply to coverage.
Well, and
so you say I see the fine line between them two?
Correct. And I would just add that 3408C, as well as the policy, include the word extent as well. So the extent of the damages.
Right, that's the key change to the statute they rely on. But let's just take a step back. If you have an appraiser, the appraiser's role is to determine the value of property, damaged property, right? If you get in a car accident and you have an appraiser, how much does it cost to fix the car? If it's a total loss, how much does it cost to replace the car? Appraisals look at value. Here, the dispute isn't over value, it's over how much of the claimed damage was caused by the windstorm in question. Appraisers, that's not within their bailiwick. That's not a valuation issue, that's a credibility issue. That's making findings of fact. Did the windstorm cause just that small damage to the roof, like the carrier says, or did the windstorm cause the entire damage? That would be subject to maybe arbitration, but appraisal, those people are trained to determine value, not the issue that it seems that you're calling upon them to determine.
And to address that, Your Honor, I would urge the court to take a look at the prior statute and the current statute. So the prior statute did have that limitation. It did limit the appraisal process to value. That predecessor statute provided all appraisals were limited to determination of actual cash value and/or replacement costs, or the amount of the loss, et cetera, et cetera.
Right, and the statute was amended to say to the extent of, but let me give you this brief hypothetical. I'm driving a car and I drive off the road and hit a tree. I have no fault. Hit the tree head on. I have damage to the front of my car. I submit a claim. I also want them to repair damage to the back of my vehicle and say that was causing the accident. The carrier says, no, you just damaged the front of your car in the accident, so we're going to compensate you for that. If I demand an appraisal, should an appraiser determine whether the damage to the back of my vehicle was caused by the tree? Should that be, because that's not we're not saying how much it costs to fix the back, is a factual issue. Was it caused by the accident? And you're saying that is something an appraiser, not an arbitrator, but an appraiser should do?
Correct. That pertains to the extent of the damage caused by the covered event.
Okay, so your argument is basically, they come in, they give a full valuation, $500 and some thousand, and then at that point, you go and you litigate as to what portion of the 500 and some thousand is going to be excluded or not excluded.
Correct, Judge.
Okay.
So
I thought of that, but once again, when you look at the statute could have made that very clear if it wanted to, saying everything's submitted to appraisal, and henceforth any exclusion will be covered, will be determined at a later date. And it doesn't seem to say that to me. And we're taking that little added language to say that it changed the whole complexion of the statute.
Well, Judge, the other thing the appraisal statute doesn't say, nor does the policy, is that the mere existence of any coverage question bars the appraisal process. So if we look at the plain text of the policy and the plain text of the statute, neither of those written provisions state that coverage issues must be determined prior to proceeding to appraisal.
So it must not, so you're saying it doesn't say it must be, but the court in this case, I think if I read the order correctly, said that, I think it was, they're going to deny the appraisal request, but subject to a determination and plenary action on who's at fault, and then allow an appraisal after that is decided. Why would that not be the proper procedure here, to let a plenary action determine who's at fault for what portions, and then do the appraisal, so that you'd limit the engagement of the appraiser to only the areas that are allowed?
Your Honor, I think from a practical standpoint, having to delay the appraisal process pending resolution of a plenary action takes years. Case in point, the Pilkington case that was decided by this court prior to the time that the now operative statute was adopted took over 3.5 years.
Excuse me, Ms. Krangle. How would the time change, though, if you, instead of doing the plenary action first, you did the appraisal and had an appraisal, like in this case, the difference between what is one side believes has to be appraised and the other is pretty dramatic, and I would think that the expense of the appraisal would be pretty dramatic. So if you establish the appraisal for the entire alleged loss, don't you still then have to go forward with plenary action? In other words, that would still have to, there still have to be a determination as to what portion of that appraisal is covered under the policy.
Your Honor, I don't disagree with that, but I think that allowing the parties to proceed upon appraisal when it is duly demanded, especially earlier on in the process, helps and frames the issues, helps direct the parties towards a potential resolution.
I know, but on the flip side of the whole thing, assuming 90% was excluded, they're incurring the expense of establishing the damages or lack thereof when it doesn't even, when at the end of the day, it doesn't even come into play for purposes of valuation. You know what I'm saying? You can start to see on the craziness on the other side. Under your theory, if 1% of the 100% was covered, then we do an appraisal on the whole 100%, and then afterwards we go to court and figure out only ultimately 1% after they incurred all these expenses. It seems to me that you'd want to know what your exposure was before you went into a damage portion, so to speak.
And I also think knowing what your damages are before you spend the time and money litigating on liability also
Both sides might view differently how to proceed and where the advantage is in ultimate settlement discussions in this case. I understand that. Excuse me, Judge.
Just so I understand your position, if this case goes to, if the appraisers are going to get this case like you want them to, are they going to determine what part of the roof, all or just a portion, was damaged by the windstorm? Is that they're going to be that's their determination?
Your Honor, similar, going back to your hypothetical of the car crashing into the tree. Here we have a roof that was subject to a windstorm. So yes, the appraisers would come in and say, this is our opinion in terms of what was
damaged, not the value of what was damaged. What is the extent
of the damage in the windstorm?
Not the value of what was damaged, but who's right? Was it the roof already damaged through wear and tear and deterioration because it had never been replaced and there was already leaks in it? They're going to make that determination in your view?
I don't believe that they would specifically call that out, Judge. I believe that in the appraisal process, they would reach a determination as to what damage was sustained from the wind event.
Are they even qualified? I thought appraisers were qualified just to do valuations, how much things cost. You're asking them to do something entirely different.
And the statute and case law supports, I believe it's the Hyman case, I think we cited in our reply brief.
Aren't you asking that they act more like an arbitrator?
No, Judge, they do not make any of the coverage determinations.
But you just said they're going to determine the dispute, what was caused by the wind.
They will determine the extent, and the court would just determine in a plenary action coverage issues.
Okay. Thank you, Counsel.
Thank you, Judge.
Your Honor, Steve Piper, on behalf of Selective. I think there's something very important missing from their argument, and I'll start there. I had a whole list of things I was going to go over, and it's been lost to the initial discussions for the appellant. Here, this extent of loss, the extent of loss as covered is known. It's defined. In fact, it was defined 3 weeks after the storm. The extent of the covered loss is the tarping and the patching that was done at one point on the roof. That's the covered loss.
To the extent there's other damage.
They'd be entitled to appraisal if they disagree with the $9,000 figure the carrier gave them.
Absolutely, Judge. Absolutely. Guess what? The $9,000 figure.
Mr. Piper, could I
I'm
ask you
sorry.
to,
I'm
we're
sorry.
going to tether you right to that.
You know what?
There, okay?
My apologies, Judge. I'll do my very best. Let me
Please proceed.
grab on. So, it's absolutely right. If there was a dispute as to an undisputed covered loss, you're in, for your example, the front of the car, right? It's covered. We'll provide coverage for that, but we have a dispute over whether it's $4,500 or $5,500. That's an appropriate amount to send to appraisal. That's exactly right. And in this situation, if there was a dispute and the appraisal demand was for the extent of the covered loss, that which both parties agree, yep, that's covered under the policy, and in fact, we wrote them a letter, it was actually April 12th, indicating most of this isn't covered. It's not covered because we sent an engineer out within 2 weeks. You have the engineering report, you know what our position is. We don't see any evidence of wind damage anywhere on this roof. But to the extent we can't investigate the one area, the one defined area, which we know exactly where it is because it was patched and billed by Neff and Son, to the extent we can't tell if that's been damaged by wind, we'll give you the benefit of the doubt, and will in fact cover it. The April 12th letter, which by the way does have a reservation of rights letter in the penultimate paragraph of 254 of the record, lays it out perfectly clear. And then a week or so thereafter, Judge, there's a second letter that goes out which says, here's our estimate for the undisputed covered portion of the loss.
So again,
we'll
your
send you a check.
argument is accepting the argument of an appraisal. Their only right to an appraisal is the area that is identified as covered. For the area where there's a dispute as to coverage, there is no right to an appraisal.
That's right. That's right, Judge. And there's only a right to an appraisal on covered items if there's a dispute as to what is the value of what is covered. Here, there's no dispute. We offer 100%.
Is that what the Luati court said in the first department, that, isn't that consistent with your position? In that case, there was water damage in the first floor, and if it was caused by a burst pipe, then it's covered. If it's caused by somebody just leaving a sink on or whatever, then it's not. An appraiser shouldn't be called upon to determine whether it was the pipe or some other cause, right? Because that's not valuation. And so that decision seems to be consistent with what you want us to do.
I would submit that the Luati decision was correctly decided. And it goes one step further. It also specifically says, listen, if we have issues here, let's get the coverage issue resolved first so we can have the actual covered damages defined before we go to appraisal. I think that's the appropriate way to do it. Because as the court was talking about earlier, what Luati's talking about, what the court was talking about earlier, what the judge in the lower court ruled, if you have appraisal before you have a definition of what actually is covered, you end up redoing the appraisal.
Let me ask you this question, going back. What do you think that change in the language in the statute meant?
I think the Luati court talks about that. If in fact, the extent of the damages goes from the defined agreed covered area and emanates out, then potentially you have an extent of question, right? That's the replacement. How much can you patch in the tiles to the floor? We don't have that in this situation. Because if you look at the expert report, they not only patched it this time, but they patched that roof several other times too. This isn't a situation where they couldn't have done discrete patching. That's not in the record. But I think that's the thrust of the extent, where you recognize, all right, we have a covered obligation here. We have an obligation to do what all property insurers have to do, and that is to put the insured in the same position he or she or it would have been prior to the loss. And if we can't match it properly, then perhaps that's an extent question that goes to an appraiser as to the value of the agreed covered loss. Here, we don't have that issue. We have discrete defined areas of covered damage and then a substantial amount of dispute over uncovered, as alleged by Selective, uncovered damages. As a result, I think judicial economy dictates that the better way to go is what the Luati court says. Let's define what actually is covered under the policy, make the appraiser's job a lot easier so they know exactly what
the defined universe is that they're talking about, and you get the one thing that you're supposed to get with appraisal. In fact, this has been in the New York Fire Code since the 1880s. The one thing appraisal does is to bring finality. Having an appraisal and then going back to a plenary action to litigate coverage is not finality. It's the exact opposite of it.
Thank you, Counsel.
Thank you.
Case 16, Maplegate Anesthesiologist PC versus Nasrin. Proceed, Counsel.
Good morning. My name is Robert Horton. I represent the appellants in this case, Maplegate Anesthesiologists, PC. We're seeking a reversal of the lower court's dismissal of our unjust enrichment claims. At the time we submitted our papers to the court, there were 4 cases that overwhelmingly supported our position in this case. In 3 of those cases, courts have held, including the First Department, in the Schaefer case, that payment of the NYAppDiv4 proceeds in question to the eligible insureds, the respondents in this case, would constitute unjust enrichment as a matter of law, and that the proceeds should be paid to the parties paying the premiums on the underlying policies. Since that time we submitted our papers, I would like to note for the record there have been 3 or 4 additional cases.
Right, but aren't all those trial courts, as I think Judge Eckler might have mentioned in one case, they have to follow Scheckler, they have to follow the Appellate Division case, even if it's in a different department. They're duty bound.
Some
they
do
disagree with it.
Some they do to some extent, but I would point out that at least 2 of the courts went to somewhat extra normal, extra customary efforts to concur with the decision and the reasoning in Schaefer. In one, Maple Medical, which was clearly bound because it was in the same department as Schaefer, they went on and specifically noted it was persuasive.
6 sentences, not a lot of analysis, no facts.
Not a lot of analysis.
It was on submission, it wasn't, so we don't really know a lot about.
Well, I think with the three cases that were decided subsequent to submission of our papers, the Sullivan case, the Mid-Manhattan Physicians case, and the Mather Memorial Hospital case, all of which went into significant detail. There are also 2 cases that specifically consider the rationale of the court below, but these 3 cases all reject the reasons advocated by the court below. There are a total of 11 cases that one way or another. Now, we are not suggesting at all that this court is bound by those cases, but they are strongly suggestive of the fact that the court erred in dismissing summarily our causes of action for unjust enrichment. These cases, all of them 11, are notable for a couple of reasons. They're all decided on identical or substantially identical facts. And the facts include what is considered key by Schaefer, that our clients, the appellants, paid the premiums on the policies, and the respondents didn't bargain for any right to those proceeds. This particular case goes far beyond those 2 factors. There are a dozen factors, including the fact that our clients, the appellants, were entitled to cancel the policies, receive all dividends payable on the policies, administer the policies, receive
But
any...
is there any specific agreement or writing that says they're entitled to this?
The plan and the superintendent's decision, which are the governing documents here, along with the insurance law, says very specifically and contemplates that there's going to be a dispute between employers like the appellants who paid the premiums on the policies and the eligible policyholders. That's why it says the payment of the proceeds goes to the respondents unless there is a dispute. It's why the plan and the superintendent's decision set up a dispute mechanism with optional ADR. It is why the plan and the superintendent's decision set up a,
The plan allowed for, and correct me if I'm wrong on the record here, but the plan allowed for your client to, before the monies were distributed or dispersed, to apply for and advise the mutual insurance company, time out, we have an interest in this, where the money would be held subject to a resolution.
it had the right to stop payment to them
Did
right
they
away.
do that?
Did not exercise it, but I would point out to the court that the plan and the superintendent's decision very clearly state, as does the court in the Sullivan and Mather cases that I recently mentioned, that those were optional provisions and that the respondents in this case are, and any other objecting policy paying employers, are free to pursue.
All it would have done is possibly put you in a different potential, a different posture.
It would have prevented the money from physically going, but it did not in any way, and the cases say this, prejudice our rights to go after the money.
Back to a specific question. It appears that when you read the agreement between the parties, they talk about a compensation package, correct?
Yes.
And in that compensation package we're dealing with their Melnick, their insurance, correct? And they
Correct.
consider that part of a compensation package.
I don't really agree. First of all, Your Honor, in all the cases in question are
I
substantial.
recognize that.
They're employed.
I understand that, but it says compensation package. Then I looked to 7307 EA, and I looked to say, and basically expressly state, the demutualization funds goes to the policyholder. It goes to the named insured.
In which provision? I didn't catch that.
I think it's 7307.
The insurance law, statute law.
So it appears to me that on one hand, you have, I understand your argument, but we have a compensation, that part of their compensation is going to be their insurance. Like, for instance, health insurance. We consider that part of a compensation package, correct?
I would say their health insurance, the premiums, pays them, are a benefit they get from employment. This is fundamentally different because what is at issue is not whether the employer was or was not required to pay the premiums. The issue is whether or not there was any agreement between the parties as to how the demutualization proceeds would be divided. And there is no agreement along those lines. The
Is
plan
there any
is
indication
silent.
in the record that there was a discussion or contemplation of what would happen?
No.
In other words, you're
None.
saying it's a windfall, right,
Absolutely.
to the employees. Well, how is it not a windfall to the employer? In the
Because-
same manner that it wasn't.
because the
Let me finish.
oh, I'm
In the
sorry.
same manner that it wasn't contemplated by the parties at the time they entered into their employment agreement, how's that not a windfall?
It's
to
not a
the-
windfall because the premiums on those policies were all paid for by our clients. Every administrative and financial burden associated with those policies, whether it's negotiating coverages, selecting the insurer, making sure premiums were paid, and so on, were all assumed by the employer in this case. In short, the eligible employees, the respondents here, had virtually no association whatsoever with the policies, other than the fact that they obtained what they bargained for, which was coverage.
One of the things I found in your favor is the fact that if there's any refund in the insurance policy at the end of the year, it went back to the employer.
It went back to the employer, and it was
very clear.
applied directly against the policy premium costs that the employer paid by Millman.
Let me ask you on that issue, on the premium.
Yes.
Did the mutual insurance company forward that, the dividends to the employee who then forwarded it on to the
No.
administrator? Because the administration document between the administrator, the employer, your client, and the employees, was that on file with the insurance company so they knew who to send the check to?
Yes, and the checks went directly to the employer.
And that document didn't cover this windfall at all?
That's correct.
Okay.
Who had the right to vote on a mutual insurance company? As I understand it, the policyholders have voting rights. Not that they very rarely exercise them, but who would be able to vote here on the board of directors and the management issues?
The
policy administrator?
I don't know. I believe the respondents would have the right to vote. But that is not an issue here, but
No, I
but
understand.
I think the right to vote would belong to
Right,
the
because
respondent.
there's certain benefits of being a policyholder in a mutual insurance company as opposed to a stock company, right? The benefits are you have some degree of management over, you have voting rights, and more importantly, as has been mentioned, you have, if the insurance company makes a profit, it gets sent back to the policyholders in the form of either dividends or money that will then go to reduce premiums. Your argument, the best one for you, so that's the benefit here of being in a mutual insurance company. That benefit flowed to your client.
The benefit of the policy refunds and the dividends, the only money that came out of the policy
It didn't
prior to this
save-
came to our client.
Didn't save the employees any money.
Correct.
It saved your clients some money. So the benefit of being in a mutual insurance company inured to your client's benefits, not the employees.
Correct.
So now they're gonna demutualize it. They're gonna change it from a mutual insurance company to a stock company. So you gotta pay the people for the benefits they had when they were in a mutual company. Well,
They don't receive any additional compensation.
right, but what I'm saying is that who loses in this situation when it goes from a mutual to a stock company?
I'm not sure.
The people who loses are your clients because they reap the benefits of being a mutual. In other words, I'm trying to help you.
Yes, I understand. You can look at it that way.
And then, so if it gets changed over, they're benefiting from being in a mutual insurance company, your clients, not the employees. You take away the mutual, you go to a stock, who should then, there has to be a payout there.
And I think
who should benefit, it would seem to be your clients.
Underlying, I think, all the findings of adjustment and enrichment is that thinking, although none of the courts went down that path. But I would like to point out to the court, the one case that the respondent cited was the Hines case. And what it really does is puts into focus why we should prevail on this appeal. In Hines, what happened was the salary for bonus actually subtracted the premium costs from bonus, so that dollar for dollar, the employee received less compensation because of the premium. So in effect, that the employee in that case is the one who paid the premiums, and the court ruled that way. All of the cases follow the principle that the party paying the premiums is the one entitled to the proceeds, because it is a fundamental and very much indisputable part of what constitutes unjust enrichment.
Because if there was profits at the end of the year, those would go to the employer.
Correct.
In the form of you pay less in premiums next time around.
Correct.
It doesn't affect the employee at all.
Counsel, let me ask you this. The reason why the insurance company would send the premium returns or dividends to your client, the employer, who was the administrator, right? The reason they did that is because they had a document on file that said that they shouldn't send it to the policyholder, right?
Or that they had designated the employer.
Right.
Correct.
The
That's
policyholder
correct.
designated the employer.
Correct.
In other words, the policyholder had the right to those checks, those dividends, but they
Under
had
that
designated the employer. In a document, they described essentially a release to the employer of this information, which allowed the insurance company to send a check directly to your client.
That's correct.
That document did not contain language that allowed for what you're calling the windfall to also be sent to the
The
employer. Did it?
document was silent as to the
Okay,
proceeds
so
at
the
issue.
policyholder did not give up their rights to that money in that document, correct?
I would argue they didn't have rights to that.
I understand, but
in the case of a dispute.
Counsel, let me ask you this question. In the document, they did not give up rights to those monies, did they?
No.
Okay.
And they could have been asked to do so. I
It-
bet you in the future.
You may be right about that. I suspect no one really contemplated that there would be a demutualization of Milmick in anything that went.
This is not the first time a mutual company
No.
become a stock company, and if they wanted to include that, not only do you gotta give up the premiums that come back, but you gotta give up any cash payout if it's demutualized, they could have bargained for that.
But Justice Lindley, the important point is that the plan and the superintendent's decision dealt with it in this case. And inexorably, whether you apply the facts and circumstances test in the plan or you look at precedent, it leads only to one possible conclusion, that in these particular circumstances, the employer is entitled to the proceeds. They
Counsel,
did
you
deal
should
with
wrap
it.
up.
I simply wanted, in conclusion, to point out, if I may, very quickly, that the court erred in its interpretation of the plan, but also in its determination that the the appellant did not make any factual allegations sufficient to form it. We believe our complaint and his papers are replete with those factual, and ask for the decision of the court below to be reversed. Thank you,
counsel.
Good morning, Your Honors. Amber Storr, Hurwitz and Fine for the defendants or respondents. I want to address the issues that have been raised here. I mean, we believe that Justice Sedita's 10-page decision is very thorough. It's supported by the law. It's supported by the facts. It's supported by what he found in the pleadings. But what I do want to talk about is Schaefer and the trial court decisions that have come afterward. You're correct that the Schaefer decisions, the trial court decisions, all cite that we are bound by stare decisis. We are bound by stare decisis. Whether we believe it's right, wrong, we're bound by stare decisis. But I posture to you that Schaefer is incorrect and that this court is not bound by it and it should not follow Schaefer. It should find that Justice Sedita had the right analysis. The right to cash consideration as a member of a mutual insurance company that demutualizes is by operation of law. It's by operation of law. And in fact, even the parties who entered into the ADR process, if those cases didn't settle, the superintendent of financial services had said in her decision that this money would not be held forever. It would be distributed to the policyholders. And in fact, those that did not sue or continue some sort of dispute, the policyholders received that cash consideration. It's not a refund of premium. The premium is only used to ratio as between members. You know, how big a policy did you hold compared to somebody else? How much membership in our insurance company did you hold compared to the other members? That's all that was. And in fact, you can see on the check stubs in record 118 and 131, the calculation is in there, and the cash consideration was actually more than what the premiums paid for that 3-year period were, because it's not a refund of premiums. It's consideration paid for the memberships, for the extinguishment of the membership's rights. It's right on the first page of the plan.
Okay, so there's an offer made by the employer to all the employees. We'll split it 50-50 if you settle with us. Most of the employees took it, your clients did, but are we, for us, is it all or nothing? In other words, do we have to say all of it goes to the employer, all goes to the employee, or can we, is there a way that we can split the baby and say 50?
I think this court is bound by the law that you have to say it goes to the policyholder, because the only right...
No, I understand, you want it all.
Right.
he wants it all. Is there a middle ground legally, or can't we?
I don't think so, not legally or equitably, because.
You either win entirely or lose entirely.
That is correct, because this is the only saving grace, and what they're trying to do as a catch-all is an unjust enrichment claim. There's not a legal right. By operation of law, this money goes to the members. And the superintendent of financial services has agreed. This is how you interpret the insurance law. And in fact, all these cases, even the cases cited by Schaefer, nobody disputes that the money goes to the policyholder. The cases.
What do you say with respect to the unjust enrichment claim? They paid the premiums.
Anybody, just because they paid the premiums in consideration, mind you, for the employment, they got consideration for the payment of those premiums. They got the coverage that they paid the premiums for. They got the payment of premiums as a choice as an employment benefit. It would be the same as an employer.
Did they have any expectation that this demutualization would occur?
No, but just because it's a windfall doesn't make it wrongful as to the employer. And that's the key. There's got to be some legal basis, some basis for some ownership interest, so to speak, in that money, to say that as between these two people, it's wrongful for this one to get it. It's wrongful to the other guy.
And your argument here is they haven't established a superior right.
They have not established that. And the facts that they use to try to establish that don't establish that. And that's why in Schaefer, when the court said, when the first department said, the employee never bargained for it, they didn't have to bargain for it. It was their right by operation of law that they could specifically assign away, and they never did. And Maplegate knew that. They kept trying to get them to sign this assignment. Assign this over to us, or we're going to file a lawsuit. Assign this over to us, or we're going to file a lawsuit. And even in the decision, they have this ADR plan, this objection procedure, specifically because on page 23, it's in record 49, the policyholders, when they're talking about the insurance law, they say, but it also recognizes that such policyholders may have assigned such legal right to other persons. So you may not have used Milnick's designation form, but you may have assigned it in a contract some other way. But it had to go from the person with the ownership rights to someone else.
And your argument here is the policy administrator is not the person with the legal right?
No, and the plan was very clear about that. The policy administrator, and so was the decision. They specifically say policyholders have a right, or policy administrators have a right if they believe that they got assigned this in some other contractual form. They can object to this, but and try to make a claim that we really do, we should get the payment. But it's got to be an assignment form. It's not just, oh, it's unfair. Oh, your 401k increased.
I think we have that argument, Council.
Yeah. Okay. Thank you very much.
Thank you. Case 18, Mason versus Caruana. Proceed, Counsel.
Thank you. May it please the court, my name is Jacob Zoglin, and I represent Eric Caruana, the appellate. This appeal relates to Respondent Ann Mason's motion for summary judgment on her foreclosure claim.
Counsel, we read the papers. How much is left? How many issues are left after our November 8th decision? That cleared up a couple of these things. What's left here for us?
So I believe, Your Honor, that no issues remain for the court to address today. The court, in the November 2019 decision, found that Fred Mason operated the gas station of the property that became contaminated when an underground storage tank leaked, discharging petroleum. The court further found that that at the time the property was sold, Fred Mason was in the process of remediating. And the record on both that appeal and this appeal showed that Fred Mason did not complete the contamination. And in fact, the property was not restored to pre-spill conditions at the time he stopped his remediation, and therefore he would still be liable under the navigation law and under our other claims. As you also mentioned with regard to the court's November 2019 decision, the court also held that Ann Mason, as Fred Mason's assignee, incurred assignee liability as a matter of law, and therefore Caruana may assert any claim or defense against Ann Mason that he could have asserted against Fred Mason.
So everything is law of the case. We've already decided these issues. There's nothing to argue here in your view?
Yes, Your Honor.
Just
That's
want
right.
us to do what we did before.
I completely agree, Your Honor. The Appellate Division should do exactly as it did before, find that as a matter of law, Mason's defenses fail, that Caruana's navigation law claims are valid, that the completion agreement argument that Ms. Mason argues has questions of fact that preclude summary judgment, and that she failed to meet her burden. Just to make a couple more steps on the issues that were found by this court's decision in November, the court noted that Ann Mason's innocent lender exception to the navigation law fails as a matter of law, and the court specifically said that there are tribal issues of fact regarding the completion agreement. Ms. Mason never appealed that decision, and so as you mentioned, Your Honor, the law of the case doctrine applies and requires that those same holdings be applied here as well.
Well, I just want to clarify. I didn't say it applied. I was just wondering if that was your position.
I'm sorry, Your Honor. That's correct. That is my position, that the decision issued by this court in November of 2019 applies. I'm prepared to talk about any of the issues, but it sounds like you're well-versed in them. Of course, you were on the panel for the 2019, so maybe for the benefit of the rest of the panel, I can continue to address some of these issues. So with respect to the assignee liability issue, which I think was one of the issues that was most touched on at the last appeal, the case law for the last 100 years supports the well-settled principle that when an assignee transfers an instrument, or when an assigner transfers an instrument to an assignee, the assignee takes that benefit subject to any liabilities that could have been asserted. So those two things, the benefit of the assignment and the liabilities of the assignment, are inextricably intertwined.
So any counterclaims that could have been asserted against the decedent can be asserted against the wife?
That's correct, Your Honor.
But that, once again, that was decided in Mason 1.
Correct.
Correct, Your
So,
Honor.
I mean, we're familiar, even though we weren't on it, we read.
Okay.
But just so we're on the same page, and I think we made it clear in our decision that, yes, you can assert the counterclaims against the wife from Fred, but only as an offset.
As an offset.
Right, so you can't get, if the amount for remediation is more than what's owed on the mortgage, you can't get that. Do you agree with our reading of that, your reading of this case?
That was the court's decision in the other appeal. I don't think that's borne out by the other case law and assignment. I think that's a more narrow reading. But I would also put forward that Ann Mason also has alleged that she's entitled to attorney's fees. So we would be entitled, even under the what I've characterized as a more limited reading of the assignment liability issue, we'd be entitled to anything that she's claimed for the value of what she alleges was what remaining on the mortgage, plus any attorney's fees because she alleged that she was entitled to it under the mortgage.
That's an issue for down the road, right?
Yes, Your Honor, correct.
You should wrap up, counsel.
Unless there are any other questions, Your Honor, I'm willing to rest on my briefs. Thank you so much for your time today.
Good morning, Richard Franco for the plaintiff Ann Mason. It sounds like everyone's very familiar. I just wanted to discuss this completion agreement really briefly, as I discussed it on page 13, and I referenced the Leon Holdings case from the Second Department, which I believe is very similar to this case. We have an agreement with the state to correct, and then we have an agreement with a third party which limits liability based on the state's findings with regard to the corrective plan, specifically the issuance of a no further action letter. Now, the prior order in Mason 1 narrowed the issues down very much so that the liability rests largely with whether or not Caruana waived the right to make the navigation law claims. And as I cite on page 13, seller's responsibility to take remedial action as concerns spill 0170200 at 92 East Main shall terminate at such time as the New York State Department of Environmental Conservation determines no further action or no further continuum action is necessary. I think that's very straightforward. I think I don't see much ambiguity there. Obviously, I know that's up to you to decide that, but I would rest largely on on the clear meaning of that. And again, I really.
And DEC issued that letter in, was it April of 2007?
Correct.
Yeah. Okay.
So unless there's any other questions, I would just point to Leon Holdings and rest on my arguments.
Thank you, counsel.
Thank you.
Case 19, Doe versus Hoon Choi, MD.
May it please the court.
Proceed.
The issue that plaintiff presents here is rather straightforward. It simply involves the application of well-settled rules set forth by this court. In the last decades, courts had 7 decisions at least regarding liability of a resident. And our argument is that Supreme Court below erred in its application of those principles to the facts of this case.
And the assertion here is that the resident exercised independent.
I'm sorry, Your Honor, my hearing is pretty bad.
Okay. I think Justice Whalen is going to tell you to move back over to the center. And I'll speak louder.
We'll speak up. Tell us if you can't hear, though.
Okay. The question is whether the resident exercised independent judgment.
Yes. Yeah, in that situation, our argument is initially straightforward. Clearly, Dr. Choi exercised independent acts of medical judgment, did so negligently. Our medical proof in support of that is basically uncontradicted. He misread the CT scan. There was no one telling him how to read it or anything. He did it himself.
What about the argument that he just relied upon the radiologist's review?
That's belied by the record, Your Honor. Supreme Court construed the record to find that the radiologist's report was okay and that he was relying upon it. Now, if that's true, we have no argument. But the facts show that the radiologist did not prepare that report until the next day or at least several hours thereafter. I'm not sure where Supreme Court found that. I'm sorry, thank you. I'm not sure where Supreme Court found that that fact that he was relying on. It's simply not supported in the record.
Right, but I think what counsel is going to argue is that the report may not have been written or prepared several hours later. The report may not have been transcribed until several hours later, but the radiologist, Dr. Metto, verbally communicated his review of the scans to Dr. Choi right then and there. And that's what Choi relied on. In other words, they're relying on not when the report came out in paper form, but when they reviewed it, he said, yeah, this is what it looks like to me. Am I understanding?
No, I would disagree, Your Honor, with that interpretation of the facts. Dr. Mehta, the radiologist staff, did not really get involved in dealing with this until after the critical time. The CT scan was 2:32. Everything, the call to Dr. K, I'm calling Dr. K, I don't want to embarrass myself trying to pronounce the name.
So that's what I was going to do. Me too.
Was around 3 to 3:30. Everything took place after 4.
There was no time at that point, and I believe the record will support me on that, Your Honor, that Dr. Mehta couldn't have interpreted that scan. And in that situation, everything that Dr. Choi said to Dr. K, and Dr. K verified that in his deposition, page 332 of the record, that I relied upon what Dr. Choi told me and his interpretation.
Regarding the interpretation of the diagnostic study?
Yes.
Okay.
And that, we believe, is clear, active independent medical judgment.
But did Choi consult with, when those CT scans were taken at 2:37 a.m., did he consult with Dr. Lee, the chief resident, and Dr. Meto about what was shown on there? Whether the ventricles were enlarged or whether there's a difference between the old CT? Was there some discussion and consultation, and when exactly did it occur with respect to the 237 scans?
Well, the two other physicians that you mentioned, Your Honor, were involved at this. There's nothing in the record that shows that they talked about what that CT scan said, other than, let's call Dr. K.
Yeah, so if we go in converse, we have Dr. K saying, I relied upon Dr. Chow's interpretation.
Correct.
Based upon Dr. Chow's interpretation, I formulated a treatment plan. So we know that.
Correct.
So now we go back, and I guess Justice Lindley's talking about where did Dr. Chow obtain that information? And it appears here that when my reading of it, that he looked at the CT scan himself, and that he forwarded only one film to Dr. K.
Correct.
And so there's where we're talking about the independent medical judgment coming in.
Correct. And even that forwarding the scan, that was done, Dr. K was unclear. Memories, I just don't remember. Something was done. There were some notes sent by Dr. Choi, but they were really garbled. But the key is what you're saying, Justice Sentra, is that he relied upon the CT scan. Right. And it was misinterpreted, according to our experts.
And Choi he texted over one image out of 120 images from the CT scan.
Correct.
Texted over to Dr. K, who was at home, a grainy, and that was the extent of what he transmitted. But I guess the argument that seems to make, you have two arguments, but the one that strikes me as more persuasive is Choi's incomplete report of the facts, that the patient, apparently all he communicated was that she was agitated and confused.
Correct.
And I guess your argument is that left out a lot of vital facts. There's thrashing around, the loss of sensory. If Choi had fully briefed Dr. K, Dr. K's response would have been a lot different. Maybe he would have ordered the drain right then and there.
Correct, Your Honor. That's our second departure. I focused initially on the scan, but also our experts said, bill of particulars are quite clear. Two departures. First was misreading the scan, and secondly, giving the incomplete clinical procedure. He was very cursory. Dr. K said he didn't say that, and even Dr. Choi said, I only said these things. And again, our experts say that was, as you're saying.
Counsel, the departure is one question, though, but we're really focused here on the independent, whether he exercised independent medical judgment, right?
Yes.
I mean, that's really the focus of this. And if we find that he did not, then the summary judgment is properly granted. But really what you're saying is a question of fact remains for the jury to determine the issue of independent medical judgment.
Yes, and I think there's no doubt about it, Your Honor. This is, at the very least, I mean, we're not moving for summary judgment.
Right.
Clearly, he exercised independent judgment. Now, the argument made by defendant is that, well, he's under the supervision. It's true. This court's decision always say supervision and direction. There's nothing here that directed Dr. Choi to do the scan from the attending, from his chief resident, from Dr. K, or did anything else. This was nothing here that told him to do this. He did it, and then according to the protocols, after he did read all this, he did, in fact, call Dr. K. But again, it's all after the fact. And the direction was based upon, sorry, Your Honor, the direction was based upon what he had told him.
And in relaying information, about the patient, agitated and confused as opposed to thrashing and all those other things. That was, Choi was exercising his independent medical judgment as to what facts to relay to Dr. K.
Yes, yes. And there's no doubt about it, the hospital charts indicate all these objective signs that were there, and he never reported them. Now, whether he felt it was, again, it'd be the question of fact for the jury, as to whether it's negligent, independent, he just didn't do it. And our experts say that that gives rise to a departure. So basically then I can conclude is that we have here acts of independent medical judgment. Dr. K never directed him to do this. This is all done on his own, and he erred, and we think at the very least it's a question of fact for the jury. And I'll just leave it at this. If you look at this record, and you say now you want to consider accepting the defendant's argument about supervision, yes, there was supervision. Basically what you're saying is that a resident who's basically working the night shift at a hospital, treating all these patients, he's now going to get a free pass because he was working, quote, under the supervision of the doctor. And that's simply not the law. Thank you, Your Honors.
Thank you. Counsel, for future reference, did that assist you?
Pardon me?
Did that assist you?
Terrific.
Oh, it did, good. Thank you.
My hearing is bad, and of course my hearing aids, worst time to crap out on me, to bail out on me over the weekend without being able to get them back.
Fair enough. Thank you, Counsel.
Good afternoon. May it please the court, I'm Rob Goldfarb, appearing for the respondent, Dr. Hoon Choi. This summary judgment record, carefully viewed, establishes that Dr. Choi did not exercise independent medical judgment in determining the course of treatment giving rise to the claim here. With respect to the CT scan, Dr. Choi did not independently interpret the scan, and nor did he determine the patient's treatment based on that scan. I'd note that Dr. Choi is not a radiologist. He's not certified to interpret or report on CT scans. But what occurred here is that after the scan was performed, the radiology department first discusses the scan findings with the ICU resident, Dr. Singh, and then Dr. Choi does review the scan, but not independently, with multiple other people, with Dr. Singh, with the ICU attending physician, Dr. Zaccaro, and also with Dr. Lee, his chief resident, who he's acting under the supervision of, as well as the attending neurosurgeon. Dr. Choi does then send images of the CT scan, along with images of a prior CT scan before the operation, to Dr. K, as we're calling him, and spoke with him.
These are the images that are sent over the phone.
That's correct, Your Honor. Yeah. But I think what's critical is that Dr. K testifies clearly that these images were adequate for him to make.
One image.
I believe there was more than one. I believe there were not the whole series, but the record will correct me if I'm wrong, but I'm pretty sure there were multiple images.
I thought there were two, one from the prior scan and then one from this scan so they could tell if there's any difference. But maybe you're right.
I believe there was more than one from the second scan. The record will correct me if I'm wrong. It was not the entire series. But what's significant and I think dispositive here is that Dr. K testifies these were adequate, and I did make an independent determination of their significance on the patient's condition.
Is it significant that he said he relied upon interpretation from Dr. Choi?
If you look carefully at his testimony, he says he does use the word rely. And I think what he's saying there is, of course, he's taking into account what his resident is saying. They're discussing the scan. They're discussing all options in relation to the scan. But he is absolutely clear that he made the ultimate determination of what these scans were showing.
But didn't Choi tell Dr. K that the ventricles were not enlarged during that phone conversation? And that Dr. K relied on that, because that's a significant factor.
I do not recall anywhere in the deposition testimony where he said that the ventricles were not enlarged. That was a determination made by Dr. K upon reviewing the
His own-
scan, and
okay.
Dr. K did testify to that.
Okay.
And of course, the record is also clear that after the two discussed all options, it was Dr. K who made the ultimate decision of what treatment was to be provided at that time, and specifically not to order an EVD.
But he was specifically asked, if you had known that the patient had, goes through the process of the pressure, would you have gone to the hospital to see her? His response, I would have asked Choi to put in the catheter EVD. You see, that's what his question to him was, if you had known it, what would you have done? And he says, this is what I would have done, so specifically.
I think what he's saying there, Your Honor, is if he had known that based on his review of these scans, it's a hypothetical of if he had seen this type of enlargement of the ventricles, what would he have done? And in
But
fact,
aren't
when there
those-
was another scan that showed it,
Counsel, aren't those the very things that juries are impaneled to decide? In other words, the doctor's testifying to this, I think what he meant was that based upon this information that I think he had. Aren't those jury questions? And isn't that why summary judgment's deemed a drastic remedy?
here, in order to get past summary judgment, there has to be some proof that the medical resident here made an independent determination on treatment for which he can be held liable. And there simply isn't that proof here. He played a role here, he reviewed the scan results with others.
There's no doubt he did, at least my review, that he did not develop the treatment plan. But it was the Dr. K who relied upon the information that developed it. So what you're trying to, so that's where the nub of it comes in, is that his independent review, or his review of the situation, the patient, what the patient was doing, the medical records, that he relayed to Dr. K, and based upon what he told Dr. K, a plan. Now, if somehow or another he misinterpreted, misread, gave something erroneous to Dr. K, which ultimately resulted in an erroneous treatment plan, would you think he'd still be not be responsible?
Part of Dr. K's independent medical judgment as the attending physician here is whether he has sufficient information to make that determination that's coming in from his resident. Dr. K could have done many things.
So the answer is this: if Dr. Choi gave him an erroneous interpretation of the CT, and based upon that, Dr. K provided the treatment plan going forward, it doesn't matter if it's erroneous or not, because it falls on Dr. K's shoulders, because he trusted his resident.
If in fact Dr. Choi had made some independent determination of what the significance of that CT scan was, he simply didn't do that. The radiologist assessed the CT scan. I don't think it's correct that the report was not available. The report indicates it was transcribed at 2:42 and dictated. That's at page 553 of the record. And the radiologist testified at his deposition, the site is in my brief, that the report was available in the system at that time and was surely reviewed by all of the individuals here. But there's simply no proof here that Dr. Choi made some independent determination himself of what that CT scan showed. I'd like to get to just briefly the second claim, that he didn't fully convey the patient's condition. I don't think it's supported by the record. At page 163, Dr. Choi says, I conveyed all of my findings to Dr. K. And Dr. K did not testify that Dr. Choi only told him that the patient was agitated and confused. If you look carefully at his testimony, he initially testifies, this is at page 160, Dr. Choi told him this and more, but he'd have to consult the medical note. When he did, he testifies that Dr. Choi also told him the patient had a change in mental status, was not answering orientation questions or answering inappropriately, but was opening her eyes to tactile stimulus. But again, what I think is critical, that Dr. K testifies clearly that Dr. Choi provided him with all of the information that he thought he needed
So your
about the
argument is
patient's condition.
It was provided, and it was he and he alone who made the determination as to the course of treatment.
That's correct, Your Honor. For those reasons, Supreme Court properly found no triable issue on Dr. Choi's liability as a junior resident here.
Thank you, counsel.
Thank you, sir.
Yeah, anytime. Actually, there's a setting on it where.
I didn't realize they had that available.
Yeah, we do, yeah. There should be, when you check in up front, there's.
It worked terrific.
Yeah, and then you can always set it to, if you do have a hearing aid and it's not working great, you can always set it to, well, that says T's. You know, I think this is a different place.